Ahmed Anas Adam for friend na swallow no na number 12 na football ho dwirim nyema yete ye no owu ye no Anas ne hu bi no kum sa brante no so these are largely nyema Anas dwen say asem na Kennedy kan egu ne hu fin into the court no process in starting with the USA
and one sempa what do we know Eugene
na so far no ne minim ne say na jury system na wo US no e de cost aba
jury ye den
na jury is in the US no jury system na interest say ye bebu asa once Ghana the judge ne be weigh the matter on the evidence of the case now the beba no
your kind slave
na ne che ne say ye de no e judge papa ba ku bi neto na panel of judges na be judges be 3-5 obi no me hwe evidence akokwa de ba say Jantuah bu nanim ase o me hwe evidence nyina no ma hwe course na pe na judges na decide to give you sa course na so better so na de but na US ye ne kakra ma kan from land for so mom de ne jury system say be yin crofobia wo community no na de o ma betrebu e plumber obi ye teacher obi ye judge obi yo omunyina obi anya enyomunya na lawful obi with various backgrounds
no wotie bi
no betie bi
I to say e bi amama fi ye program
yes
now e bi tie
no be lines na sanko yes omo number bi e be yi wo mtina na on the basis of evidence obi abebo ni nkuro de ni on betena na omo de aba na me say na ask for more than 18 million I think say me 25 na ko bibia wi no jury no kwakra no so the 18 e bae banana because American system nim say the juries na be a verdict on the banabi e betima broso and I say be e be excessive just e betima broso no enti no mo be e friend the remittance system ne kire say e wono ana Kennedy Japan lawyers be ka say bia na jury ne de bae no e bro sene no more expectation tie enti e wono be bonkro on the 18 million figure na ba no e wo ana ye benya the actual amount and say judge ne begia to man answer on yintum banana the what I can confirm for you is that based on the rule nearby there the jury has confirmed that indeed Anas was defamed by Honorable Kennedy Japan obi busa say ye dey no costume no US na say Kennedy Japan properties e wo USA na Kennedy Japan properties ni wo New Jersey e wo na excess county e wo no court no
okay na
dey ba concern say okoye no koye show be friend the Fred show Daddy Fred one ne ko bon komo
e wo ho no
e wo US no
enye Ghana
koye show no na show no ye no ni studio not fie no ye ni zoom no ni fie na not na say fie no according to Anas documents no na say fie no New Jersey
okay
into our grounds ni bi che say Kennedy Japan properties New Jersey any US na that Fred no so to US those are not in Maryland but Maryland not in the US asase so na baby Kennedy Japan tena ase any that Fred the cars yes I interview no cool Anas hu fin no sa bia no New Jersey went no file and so there's grounds for baby of file asem no na another thing I me pick say 4 charges Anas car say on sa grounds no na Kennedy agunu fin ba ko ne say o say Anas ye kromfo
okay
or a criminal or the German phone sasani ade a okekaye 2 Anas answer can say Chinese national be abagan no mewu no Anas no in the these ankrofo them
okay
3 or say Ahmed Anas Adam for friend na swallow no ye number 12 na football ho dwirim nyema yete ye no owu ye no Anas ne hu bi no kum sa brante
okay
so these are largely nyema Anas dwen say asem na Kennedy kan egu ne hu fin into the court no process in starting with the USA na nyemiminim and so far ne ma kind from lawyers they say the court has indeed ruled say yegu Anas hu fin but the remittance system no and so be determine say 80 million na jury for no
$80 million
no mo de buy no sa na say eye and I say there will be variations in the cost na say best sa na meminim so far
my name George Sapon entry and come when him say George apart from politics a student of law enti onunso egusua o follow discussions na o chichi nyoma bi mu ti e pese ti asie yi George Sapon so na oye active member our MPP mu in fact oko
parliamentary candidate aspirant fija kwa abre I think south
next year 2028 they also mo demand because we abre but we nya hwe wo party whatever fa senior Joseph good morning
you were na Baba will be happy, sir. Probably I didn't need it.
If you say make out say what bread and she was here home till 2028 year could you sit in a bro. Sana make seminiano.
Ah, you waited the week of shower Eugene for the for I think that's the Katai, Mama Fisher.
Boame kakra de akoso anase die nim no Eugene achirichiri mu kakra but say Kenya po ye bua no aten ana ye bua na ten.
Okay, I think say the kind of adebako say Chigana for if you say who say ya temua munsem no ye kotumusem no sa asem kokota ye wo kwan mienu a ye fa so bua ten. The kind of say dia otemofo no kwa betina se no afa Ghana ma nhihye ya ye de fa so bua ten na wo bua ten. And I say, Obefa Boafo, I from jury. Now for your most so abobo said, Nelson said, you should jury now. Utimofo and matches on chair or more acquire or more faso, and she shouldn't see mu. And they say the evidence between anima, quite being no more faso, or church in be much romo, and Rabena, a walk for no more ben also what they call I been dream, Sandy na or church romo. Now for your man, show monkey say, and the Timofon betcha Omundi Subiano, and also with this of Pepe. It was Timofon, yes, idea will be now. As my can issue US court, no, or we use jury system, no, I know Timofon betcha Musamuni ABC now Muria or more Ancasa Omuay and I want to be court, no, the verdict, no, and no, the Timofon in him who shade. Na omo and omo de beba. And so it's important say they make a distinction no. Now we are say jury in the decision bar and the verdict bar and yet conclusive enough. Say jury no econo kojinjin sem no ba no si o and some court na de mai say na e den fa ho a en CP. I just a court no fa sa asem no. Now, Bunibeka say or internal as a decision or a judgment of the court. Court never carry fast the adoption. Also, court ne just as no. Now, court nankasa a team so say we ne ye muaya court no e de Bible thing. And in such matters, the court necessarily has to take the verdict and enter it as a decision of the court or a judgment of the court. Anything short of this via any judgment. And he said. Who pay attention to some of the arguments on our social media, which is the Professor Koku Asare. The post of Omekia is generally a lot of conversation. He was very specific, saying the jury in the SS court has awarded a verdict of 18 million against Kennedy Japan. One can say the court has awarded a judgment of. And sometimes I think that those distinctions are key. And there it has there is no judgment against Kennedy Japan. Legally speaking, there is no judgment against him. Now, per US laws, no, say, yeah, what these damages against you, yeah, Bob, say, what can be any okay, now, yeah, Cassie, could you get him for? There is this legal principle I friend remedy so. And no chair says, say, a bulk our quarter, a man of my whole point says, oh, did this as I can, a brosum far, Okona Cocache. Court and say the idea to me I say no me won't sue so na me tabono aka sue neja me de madam me buru won se so mame court ni bit me ahwe na wa hwehwe sense no we shine the entire my US for this principle ne by any say who ye case in the normal system where you have a judge sitting on the case the judge he is guided by the rules of law, the facts and all legal principles. But in a jury system, no, the jurors are not necessarily making their decision based on the rules of law or the specific provisions of law. For example, say a judge or making an award against will be for damages act. Or maybe make specific awards, for example, for the road traffic offense, causing harm to other road users and everything. And running say a 20,000 penalty and a 100 penalty unit penalty that could be 12 cedis. So he will multiply that by that. But a jury can make some decisions no matter how outrageous they are. And I didn't say the whole jury system is built around the perception that jurors may form every they represent the larger society. Their feelings are that of the larger society. And sometimes they may go overboard kakra. So for example, when the judge is bidding come, I don't tell you. There was this case, case I think it happened in Ashanti region. And we are 4 million and about a kubako. So it's a murder case. Facts in a murder case. Now, judge every jury now call you no. The expectation is that they will come up with a guilty verdict. Mm-hmm. But the star witness in the case was boy now ne mami. Mami ne ma say stand no. Asema o catch a jury ne say you say about time me be okodema why ne be me. It is not that the boy has not committed murder, but the woman is appealing to the emotions of the jurors. And jury system is say, you know how to appeal to the emotions of jurors. Oftentimes you can have a decision going your way. It's mamia bet now. If it's a matter before a judge may decide. The judge will go strictly according to what the law says, Section 29, Section 30, and then and sentence and then life imprisonment, death sentence, whatever it is. That is what the judge will do. But a jury has to now come up and say the person is guilty or not guilty. Or not the verdict judge is who should be. And they are not making that decision necessarily on rules of law. At best, they will do so based on the facts available. If we are not a jury system, sometimes it may not necessarily bring out what we consider the best option. So, for example, the U.S. court, any journalist who goes to a U.S. court for defamation is likely to win, dependent on the kind of arguments that the person makes. Mm-hmm. You could see the arguments made in the U.S. court. He created the impression that in Ghana, some people are above the law, especially politicians.
Right.
This is a statement that will appeal to every single juror in the United States or any part of the Western world, whether it is true or not. What's the mechanism? Because we're all here when even President Trump was hauled before legal processes and all of that.
Right.
You see, so before a jury, you have the chance to. You can even be manipulated and get away with it. Mm-hmm. Jurors are sentimental. It is a profile jurors who say, if we have name, but we or a Christian, we say, you know how to play with your arguments to get them to give you the kind of.
But Sir George, and no dear, more na more yellow juma. Obviously, some court. We can't so be making an argument, but superior arguments in the winning. I'm sure, sir. Canada Pon Nankasa intimidate Ninsesi in the book and say me Miwusika, I'm going to pick the best lawyers, underline best lawyers.
Yeah.
And I'm very sure, say the best lawyers now Canada Pon Ju Mudino. Omunim all those things say they are during the say it here. And say one kawa sim ya ye be buetia. Because honestly, I'm saying this because the ama excitement in Nabano may not be necessary because of Canada Pong. But there are not excitement to me, Nibia, but no echo to say, Anke Ghana ha, Kebe frustrated system na, my one share crana, say Nipanuka would be man now, would differ, now problem. And a case study could be, Yamfani say, can JB Dankwa MP. Look how many years in ye. Yintimi nyai but there be an enka ya brochira kietie na asebe hu se wodi fo na se odi bem obi betime de na sama kokot wa ha ni a frustrating na ye nyina ya victim pain ye be frustrating na afi na wajai but there be a abrochire ni de se eyo se nya kra na ye betie is it not something na emma yes at least your court system no we need to work on that.
No, I think that comparison is a wrong one. First and foremost, once you infer a jury case and compare a street case, where it is an indictment proceeding, a wrong comparison. The modes are very, very different. I have to say, if I say, Obi episode of compare a radio show host by his ability to write. It's not necessarily the thing. Now, Ubana Obeshe is a kind of the example you made, the JB Danko example. Let's even stick with that example. It is a murder case. Doing a murder case in Ghana, doing a murder case in US, there are things that would help you. But generally, there are some principles that would guide you. Every murder case, there are two ways of assessing evidence. There is what we call the preponderance of probability and a balance of probability. So, you are putting things together to suggest that there is a likelihood something happened, or there is a likelihood that something did not happen. Into the kind of mabu match say, oh, bibi say adie ebi asane by, and now say anyesa. But your quite to say meda, it comes under what you call prove beyond reasonable doubt. I also to me share evidence ni musu nebeya obia jene tanta. So you cannot compare these two situations. Now I back to even the jury process. Now I mentioned earlier, say the judge or the court instructs the jury on exactly what to do. If the jury in any way deviates from that specific instruction, it becomes the grounds for mistrial, which is one of the contending issues before the court now. Now, court, Emma, jury, and Ejuma Miensa, say Omunkonkoye. First and foremost, the jury was supposed to decide, say, in Japan, or you're guilty and or you're guilty of the issues that have been brought before the court. Now, the second thing the jury was supposed to do is say, or you're guilty, yeah, then you should assess actual damages. Actual damages are in Germano. Beyond that, you should also assess defamatory damages. Now, the court set a different date. So, Baba Bishia to come and assess what we call punitive damages. Punitive damages, say, assessment, was it of an aggravated nature? Ebiana abro so nipano or they could do baby anything or they could do an abibisa. Court, eba SHA so baby assess punitive damages. The jury now, so the court asked the jury, said, on this you are to assess punitive damages. The jury now says that, oh, the OCA, now on the Friday, last Friday, he assessed actual damages at $5 million, compensatory damage at $5 million, and punitive damages at $8 million. Meaning now, $18 million. And then, there and then, the defense counsel, Canadian raised the issue that this is grounds for mistrial because instruction now court in the jury, it appears that now, if you listen to the video now circulating now, the judge, in acknowledging the verdict of the jury, indicated that he was going to, and before that, he had mentioned that he would not take oral submission for mistrial. Who is the purpose of submission? If you are all the one on account, if you want to, when the judge feels that the matters are weightier, a way to kakra, or better choice, come on the record. You have to come with a written submission or a written motion. The judge told them, say, on the issue of mistrial, he was not going to entertain an oral submission. So the parties should come with a written submission. And then Canadian lawyers have taken steps to file the written submission. Now, when that is done, court was 30 days to determine the issue of mistrial. Two things are going to happen. Either say Obebua in favor of Canadian Japan. When that happens, it means that they will have to reconstitute the jury for a retrial. The Canadian Japan favorable verdict, he has the option of going to an appellate court for a review of the decision. Now, the court can either also rule against him and those things. Now, if it happens that way, so it also brings to our minds the other issue of the defense team also asking the court, say, why they are so much into court into so. That remittance application, the court has two options: either so we accept it and I won't accept it, or accept here or better bonus. One accept into what? Then also the head the whole. Obviously, we can say, now also there is a mistrial. And then I will say, Papa, catch a court and say, yente bonus amount. Now, every smart lawyer, so a case, or measure all the available options. Now, you want to be in a situation where all clients now are not going to be the best form of remedy available. It's like a they are near 10 years. Now, I had the year over them now to over 2 hours. Wabuano, and I'm a boy. And see, the lawyers they are looking at two options. One, to get to the mistrial application successful, in which case it will raise doubts about the initial jury and whether or not they knew their work. It's a mistrial, no quite everyone. Remittance application is called everyone. But in matters of law, it can go either way. But he has remedies even in the appellate court. So that's basically it. It's
right.
It's nothing like a judgment. These processes would have to terminate before the court comes with its final decision.
Matha, senior, Medasi, I'm sure say a developing story in TBBI was about so.
Matha, Nakache, you just say, my sister, when you can see on Kaimi.
Mekachin. You say, do you sky any best opportunity? We but Jantuah Sapon, will be our follow legal matters and in the right,
and a show at the V.
Nanisarpong Studio.